welcome to this Trinity webinar. James and I were going to discuss briefly for you the impact of the Duchy Farms recent decision, particularly on confidentiality clauses in compromise agreements and COT3s. And I think James, first of all, is going to take you through the circumstances of the case.
So yes, Duchy Farms Kennels and Steels was a recent High Court decision which dealt with the impact of breaching confidentiality clauses in settlement agreements. It's worth taking a moment just to look at the position prior to Duchy Farms, which would be that I think most of us, I think Richard would probably agree with this, we would quite often draft settlement agreements with fairly standard confidentiality clauses in them without giving much thought to the content of them, unless you had a case with sort of particularly sensitive facts that meant confidentiality was going to be more important. If you didn't have a case like that, usually it would be a sort of a standard clause that you'd chuck in there almost as an afterthought.
I think in truth, it sat really on the precedent bank of probably most solicitors firms doing employment law and most barristers doing it as well.
Yeah, I think that's right. I think Duchy Farms will change that. What you'll see firstly this slide is that with the citation and the link to the judgment on Bailey, these slides will be made available along with this webinar, so you should be able to have access to the judgment fairly easily. We'll just briefly take you through the facts of the case. Steels was initially the claimant in employment tribunal proceedings against Duchy Farms Kennels. Those proceedings were compromised by way of a COT3 in January 2019. There were various terms, but the main ones were that Duchy Farms agreed to pay Steels £15,500 by way of numerous weekly instalments of £330 a week. The COT3 contains a fairly standard confidentiality clause, which we'll go through in detail in the next slide. What allegedly happened thereafter was that Duchy Farms became aware at some point during April 2019 that Steels had been discussing the terms of settlement with a third party who happened to be another disgruntled former employee of Duchy Farms. They, once they became aware of that breach of the confidentiality clause, they alleged that Steels was in breach of the settlement agreement and stopped making the weekly payments that had been agreed previously as per the terms of the COT3. Steels issued county court proceedings and Duchy Farms defended, citing a fundamental breach of the contract terms. At first instance, the claimant Steels was successful and it went to the High Court on appeal. The confidentiality clause is important insofar as many of you may well recognise it, in terms of it's a fairly generic confidentiality clause which you will have come across in probably settlement cases of your own. It's here on the screen. The parties will treat the fact of and terms of this agreement as strictly confidential, and the parties will not disclose them to any other person or entity save as set out in this clause or as may be required by law, or to any regulatory authority or to professional advisors, subject to them maintaining the same level of confidentiality. The High Court ruled essentially in agreement with the judge at first instance, and that was that by disclosing the fact of and terms of settlement to the third party, Steels had not committed a fundamental breach of the settlement agreement, and Duchy Farms were still liable to pay the settlement monies. The judgment was reached really on the following basis, with these being the four key factors. Firstly, that confidentiality was not at the core of the agreement. Secondly, that this was a standard dispute with no issues that required any particular sensitivity. So there were no unique factual features of this case that meant confidentiality might be more important. there was no significant commercial risk to Duchy Farms from the breach. This wasn't the case, the High Court said, where it may give rise to a number of copycat claims if the fact of settlement got out there. And lastly, the clause itself, which is why we highlighted it, was generic in nature and one that had been used as a matter of course in a number of different settlement agreements. Obviously, what this does is it raises a number of implications, both for settlement agreements that currently exist and drafting settlement agreements going forwards. And what we're going to do now is briefly discuss what those implications might be and how you can go about drafting settlement agreements in the future so as to avoid getting into a situation like this.
Yeah, thanks very much, James, for summarising it. So there are a few areas which we thought it would be useful to go through. One of those is the hierarchy of contractual terms, in that conditions in a contract, if breached, will be generally a repudiatory breach. And so because it was found in this case that what was being dealt with was an intermediate term and not a condition, it wasn't at the level that meant that there was a repudiatory breach and payments could cease. The other issues that arise from that, of course, is that the judge was interested in the extent of damage done by the breach. And so even with clauses like that that are in the past, it seems to us that if the damage is very substantial, so if, for example, someone who is part of a disgruntled number of the workforce brings a claim and is successful, but it's settled on confidential terms, and those terms are then disclosed to the whole of the workforce, thereby causing very substantial workforce unrest and potentially much more than just one employee who is aware, or former employee who's aware of the terms, then that may mean that the approach is different to the approach that was taken by both the first instance court and on appeal in Duchy Farms. But James, I think you were going to talk briefly about how you might deal with the need to have a condition in your settlement agreement or COT3.
Yeah, that's right. Mr. Justice Kavanagh in Duchy Farms anticipated that this may cause a problem, and so he proposed 3 potential solutions. The first 2 of which we're going to concentrate on because they discuss how you can elevate the confidentiality term to being a condition. Firstly, we would advise that you would specify why in the particular circumstance of the case that you are drafting, confidentiality is a necessity, because that would elevate it above a mere ancillary term. Secondly, explicitly specifying that it is a condition of the agreement. And thirdly, making a specific provision in the agreement as to what would happen if there is a breach of the confidentiality term. For example, parties agreeing that in the event of a breach, the party at fault repays either all of or a proportion of the money.
Exactly. So an obvious way for that to be dealt with, in fact, in all of the precedents now, is that at the start of the clauses setting out confidentiality, it is recorded that the parties agree that it is a condition of the agreement that, and the confidentiality clause is set out. Below that, if this clause is breached, the parties understand and agree that the consequences shall be the following. And for each party, the consequences will be different. For the one, monies paid would either stop or be recoverable. And for the other, a damages claim would potentially be available for any damage done because of the disclosure of the content and the factor of the confidentiality agreement, depending upon the way in which it's drafted. And I think ideally, as James flags, if you can say why it's confidential within the agreement, you should do so. In truth, I suspect we've all dealt with cases where that's not necessarily as easy to do as it might be. And so on occasion that won't be possible. But if you say it's a condition, if you set out the consequences, you can see that either side then will be hard pushed in front of a judge in either the county or the High Court to say, well, I didn't think this would happen, and it shouldn't be treated in the way in which it sets out it should be on paper. The only other thing which occurred to me is, James, I think that there are other clauses, a bit like confidentiality clauses, where the same approach is likely to be taken. And so very often with confidentiality clauses now, there are clauses like non-derogatory statement clauses. And I suspect that the same kind of approach can be expected from the courts in the future to those kinds of issues. So if someone says something that is derogatory about their employer having signed a compromise agreement which says that they will not do so, but they do it to one person and the employer becomes aware of it, I think it's quite likely that the Duchy Farms line will be followed, unless there's similar approach to elevate that clause to it being a condition, and or if that hasn't been done, the effect is rather wider in terms of the publication of that derogatory statement than just one person.
Yeah, I agree. I think you're absolutely right there. I think that unless, I think a lot of these terms are put in there as sort of, like you say, they sat on the precedent bank, and they're put in there as standard without a great deal of thought being given to them. And yeah, I think unless those are specified as being conditions of the agreement, then I suspect the High Court or the County Court would take a similar view that they're not conditions of the agreement, and they wouldn't, unless there was evidence of substantial reputational or other damage, they wouldn't lead to grounds on which either you could get the money back or cease payment of the money. Obviously, this case was slightly unusual in that most cases you will get where settlement is paid as one lump sum. This was an unusual case in that obviously it was being paid over, I think, 47 monthly instalments, and payment was stopped some way in. But yeah, I agree. I think the main thrust of it is, I think everybody now needs to be much more careful and give much more thought to the terms that they're drafting. And this will certainly sharpen everybody's focus in relation to that.
Thank you very much to all of you who are watching this, and we wish you all the very best of health and hope to see you in person soon.